Do not for 1 minute think that this is not the worst thing that could possibly happen to you. Short of a crippling disease or death, this is the worst thing that can happen, is if you lose, and most guys do. It breaks their hearts. The children suffer. So you have to be strong. All right, this is, we're going to pick up, and I want to recap a little bit. In the communication business, they called it redundancy with variation in order to get better comprehension. And better comprehension is important for you. We want you to hear this message, and we want you to remember the important high points. The first one is, go in knowing that your attorney is most inclined to act contrary to your interests. If you do not advocate your interest, you're going to lose, because they will figure out a way to undo the help that I'm giving you here. That's what they're going to try to do. You need to be very vigilant in this, and you need to remind them, I want a trial. I'm assuming I'm not going to get what I want without a trial, and I assume that I'm going to lose at trial. So don't try to tell me this is the best I'm going to get, because I know that. I want a trial because I want to win, and I want to win in the Court of Appeals. That's what they have to hear. They must hear that. Now, my recommendation is that when you go into the attorney's office, that you have a statement already written down to that effect. I'm hiring you to represent me in this divorce or child custody action, and I'm hiring you for the purpose of preparing me for an appeal after I lose in the trial court. And make sure you've signed and dated it, and you give it to the attorney at the first meeting, and keep a copy, because now it's a part of his file or her file, and they know if I don't do my job, I'm likely to get sued for malpractice. The next thing is, you need to ask the attorney for a list of the factors that are going to be used, that you understand that there's about a dozen factors, and you need to bone up on these, and you need to study them so that you can give advice to the attorney as to what you know exists as evidence that relates to each one of those 12 factors. Now, a lot of them won't apply in your case. In other words, it's going to be equal, because the home and community and school and that kind of thing typically isn't going to vary from one parent to the other if they've been living together in the same house and in the same community. But nevertheless, you need to be able to go through them, and the attorney, if they're doing their job, should be focusing more on those factors than anything else, because that's the key. Decisions about custody are supposed to be made, quote, in the best interest of the child. And the Uniform Child Custody Act, which has been adopted by virtually every state in the union in a form that's very similar from one state to the next. There may be a slight variation. So we know that those factors are going to be the factors that the court is supposed to be relying on. Now, what they like to do is they like to hire outside experts who are not really experts, but they like to pretend they are, usually a mental health professional, and usually a mental health professional who's just as crooked as the attorneys, because they like to make money by double dipping. They'll put you in a room with a test, so to speak, where you fill out answers to a series of questions, and that way they can charge you for that hour while they're also meeting with another client during that same hour. And of course, the evaluation of the answers is pretty routine, and in addition to that, they're not applicable to making decisions about anybody, because those tests are all developed for the purpose of therapy sessions when somebody's going to be working with the mental health professional over time on some issues. They're not meant for evaluation purposes, and they don't tell you anything. All they are little hints, which can be confirmed in their mind with the professional standards if they meet with you for over a long period of time where they can test these things and see if they hold up. But it does not tell you anything. But that's what's going on. So your attorney needs to know that they have to challenge those kind of things right off the bat and stick to the factors. There are lots of ways, and we don't need to get into all of that, about how you prove the factors. The important thing is that they know they must prepare for them. And remember, we're recapping here, you also have to, at some point, you have to say to the attorney, what is the date for my trial? And if they can't give you a date for your trial, then that tells you right there that there's something wrong. If you don't have in your records a trial date that was ever set for your case, the probability is your attorney was an incompetent boob. They were selling you out. They had no intention. If you were expecting a fight over custody, and that's the common way in which these cases are handled. They never ask for a trial date because the court doesn't want a trial date and they don't want to anger the judge. They're afraid of the discretionary powers of the judge in other cases, and so they don't challenge them. That's why you have to give them the ability to challenge the judge in a way that protects the attorney. And the way you do that is by threatening them and saying, I'm going to sue you for malpractice if you don't get a trial and you don't put my evidence on the record, because I plan to win on appeal. I've heard that this judge is a bonehead and hates fathers. And so that's what the lawyer tells the judge, and you don't care if the judge is angered by it, because you're either going to win before the judge gets a chance to make the decision by getting a stipulated agreement based on the strong evidentiary case that your lawyer has developed and presented to the other side so that they know, uh-oh, we're in trouble, or the judge makes the decision so that you don't care about because you're going to win on appeal. Now the probability is what will really happen is this. Having prepared a good case, the probability is the judge is going to figure it out. We won't get into how they're going to figure out that that's happened. And once they know that your attorney is not going to be able to control you, then the judge is going to look for the weak spot, and that's the other side, and turn on that attorney and say, you better get this client of yours in line. And you tell her that if she doesn't straighten up, she's liable to lose custody, so that they hopefully can get them to agree to some joint custody arrangement with you so they don't have to have this trial. After all, if you have a trial, guess what? The judge actually has to make a decision. And the judge doesn't like to make decisions because basically they don't know what they're doing when it comes to making these decisions. A few of them do, not very many. They think they do, and they're arrogant, no question about that, because they've got so much power, they're used to pushing people around. But the reality is, if you do a good job and you've got a good attorney, you can usually cream this judge in the Court of Appeals and embarrass them. Well, they don't like being embarrassed, and at some level they know that they really don't know how to defend these things because they've never wanted to spend the time to actually figure out how you do it. Anyway, I want to move on to another important subject, and that is how you lose.